All right, in line with some of our videos recently, we're going to be looking at another way to attack either a custodian of the records, or in this case, an affiant that signed off on saying you owe a certain debt when indeed you don't owe that debt as far as the affidavit shows, or the person that signed the affidavit and is swearing under oath has said she's looked at the documents and they clearly show you owe the debt to her client. In this case, it's a velocity case, and there's an affidavit that the affiant, that's the person that signs in front of a notary, signs for velocity. Let me just put it up on the screen for you. Shazamski. And that's the affidavit that we're going to look at today. I deposed that person, Miss Rivera, and I'm going to break off a kind of a two-part system here. I want to tell you, I'm going to attach to the website, the membership website, a checklist for you to sign off. So if you ever have to do a deposition, this is the thing to use. You can also take that checklist, as I've done in many other videos, in my bill of sale video, breaking it down. Let's take a look at that. Shazams. And you can see all my deposition videos. There's a number of them up there. Oh, I'm wearing an orange shirt. Let's get rid of those. And you can use those questions in discovery. You can use those questions if you're in a situation where the court is asking you why you don't owe this debt. It's a perfect thing you can use. This checklist I'm giving you, there are checklists in that membership website for all different situations. For example, there's a beautiful one if you're in court. Here's what to say or not say. Let's just look at the number I have for videos I have for being in court. Boom. But this one is a checklist how to ask a witness questions. But my point is, it's the same questions you can ask in court. Or when you're asking yourself, why don't I owe this debt? You can use this checklist. So it's another checklist for you. And I've got little boxes you can check off. But I just want to show you how it works, right? So here we go. So in this case, as with any approach to these cases, your first defense is that counter affidavit. What is your goal? To show the court you don't owe the debt as the plaintiff has brought it. So we're going to look at your goals. Now, when you do a deposition, just the word deposition, it's got a number of syllables in it, and it's not as all encompassing of so much terror and anxiety as it appears. If your goal is just to show the other side admitting they don't own the debt properly because of the, let's say in this case, the bill of sale chain of title is broken, once you get that, you can move on. I've done depositions that are 30 minutes long, and that includes, hi, how you doing? Let's just talk about your education. You have to hit it and move on, because if you score a victory, and young attorneys, especially me, were guilty of this, I'd have these great victories in the deposition. I'd want to go back and get it again because there's so few victories in the work. Don't do that, because then that gives the other side a chance to rehab the answer. So you may get 3 things answered and go, I don't need to talk anymore. So let's take a look at how successful a quick deposition was that I did. All right. So here is the witness signing out under oath. Let's put that up there again. Shazamski, the affidavit, and she's signing under oath. All the above is true, or she's going to be subject to perjury. So we'll get her on that. So the first thing, Cindy, put up the first part of the transcript, Shazam, and that is me asking the affiant, hey, how long have you been working there? 5 years. And when you say you're working velocity, she's signing for velocity. Is that who you're working for? And you can see in my pink, look at the pink stuff today. No, she works for Velocity Portfolio Group. So there's a little hint and a half for you when you have a velocity case. Go look at who really owns this debt. You wouldn't believe how many times I get an affiant or a custodian of records in front of me, and I go, so do you work for Joe Blow Collection Agency? No, not really. I work for the company above it, Howard and Associates. I just did one, my last video. That's a start right there. They're signing off as having knowledge because they work. They'll literally say, I work for Velocity. Turns out she doesn't. So you can see where if you look at the pink notices, she admits she doesn't work for Velocity. That's the start of that deposition, all right? So that's the company that signs your paycheck. So I ask her, so it's fair to say then whoever signs your paycheck is who you work for? Yes. She just eliminated herself right there. But we want to move on so that you get more education here. So that's the witness herself, as you can see, agreeing she doesn't even work for the company she works for. So anytime you get her saying something that's contradicted or that contradicts her sworn testimony, you only need to do that if you're doing an affidavit and they've sworn under oath to it. If you knock out one thing, then the whole thing is false because she signed it under oath. So we ask her about her education. And this is a good way to attack any witness, any debt collection witness, anybody that's saying, yeah, we saw the proof and your client owes it. Here's the question. What's your education? And now I've already framing it. If you look, let me put it up there. Sorry about that. Cindy put that up there on the sheet with education in the debt collection industry, Shazam. So you see, how many years have you worked for Velocity Portfolio Group? See what I'm doing right there? I'm already shaping her as not even working for Velocity Investments. And then I ask, what's your experience? And I'm reading this and trying to look at the same time. What's your experience working with debt buyers and debt collection companies? None. Did you take any training courses in person learning the FDCPA? The FDCPA regulates the entire industry. Debt collectors and their staff do not make a move unless it's within the realms and the laws of the FDCPA. It's a very serious regulatory agency, law that is enforced by the government, the CFPB. So what is your background and training in the FDCPA? She says none. You see what's going on here? She's not qualified in any way, shape, or form to answer any of these questions, and that's a great thing. So, but she signed that affidavit, remember? So listen more. You ask, has the witness seen evidence of the specific debt in the lawsuit passing between the creditor and in her case, Velocity? That's an important question to ask because that's the whole case. That's your whole defense. That's your whole answer. That's your whole counterclaim. So I get her to admit, look in the pink again. Cindy, Shazam, the one with, has the witness seen evidence? Shazam. All right, so you haven't seen whether the debt is in that pool of receivables. You're just going on faith because there's a loan ID number. That's why you believe it's in there. Is that correct? Yes. So let's look at the bill of sale, Shazam. And that is the bill of sale that she claims she read as part of her affidavit that she signed. But there's no mention. Let's put the affidavit next to the bill of sale, Cindy. Shazam. Do you see any reference there to, in this case, the bill of sale is from Upstart Funding Grantor 2019-3 being the initial seller to Velocity. There's nothing in her affidavit, as you see. So why isn't it in her affidavit? The best she can do, because these are general things that Velocity, or whoever's using these affidavits, will stick on their case. And that's what you're doing. You're driving a wedge in between the truth and what they say. You're driving a wedge in between the truth and what they are saying, what they're saying under oath, all right? So I asked him, you said that Upstart was involved in the bill of sale. Was that your testimony? Correct. Upstart Network, Inc. So I asked, there's also an Upstart Funding granted, and put that on the screen, Cindy. It starts with A, correct, Upstart Network, Inc. There's also an Upstart Funding Grantor Trust. Cindy, make sure the bill of sale is next to that. Do you see that? And she says, yes. And you understand that they're two different entities. And it's important that you do this because a lot of times what Velocity will do, they'll say Upstart gave us the thing without even saying Upstart Network, because they're trying to imply to the court that Upstart, this weird sounding trust, gave it, because then it fits with the bill of sale. So this is what they do. So you understand that they're two different entities. So that's the third admission we got from her when she says, right, I believe that's the funding source. So she admits the two entities are different, the funding source. Okay, I go, sure. But we just got three goals there. We got to admit she doesn't even work for the company she's signing off for, right? She has no experience in the FDCPA, and she also knows that Upstart Network and Upstart Funding are two different companies. That's their witness, not yours. And you're using their documents and their witness against them, all right? That's what's going on there. So then Cindy put up, so it says in the bill of sale, Shazam. So it says in the bill of sale that Upstart Funding Grantor 2019 appears to be sending some debts and all rights, title, and interest in those receivables or charge-off loans. Again, Cindy put up the bill of sale next to that. Do you see that? Yes, she says. And who gave those rights to Upstart Funding Trust? I don't know. Okay, you don't know. So now we're on the fourth thing we've got to admit. She doesn't know the bill of sale is there, and that's the only document in your velocity cases. When you have a velocity case, the only thing that says velocity received something from somebody will be this bill of sale. That, by the way, is generally always older than the document, which is called a certificate of loan sale. That document will eventually grant something to Upstart, but days or months after this bill of sale. It's also convoluted. So you push further on who gave the rights to the weird-sounding trust and get her to admit the chain of title is a complete mess. So Cindy put up 6 question, where's the paperwork that says, Shazam, somebody gave it to Upstart Funding Trust, 2019-3. I don't know. Have you seen it? No. You've got 5 admissions, and admissions are undisputed. She's in a deposition. They're coming under oath. It's not like you're making stuff up. Their own person is saying this in great detriment to their case. It's going crazy now. So you ask, do you know who gave this to Upstart? Same document, Cindy. Gave this to Upstart Funding Trust, yes or no? And then put up the answer. Cindy starts with A, no, and Q, no. Shazam? No. And then I asked, so you haven't seen that assignment from whoever gave it to Upstart so that they could give it to Velocity, correct? You haven't seen it, is that correct? No. So you ask about the chain of title and you go deep on them. You have to. Let's put up the certificate of loan sale, Shazam. And then we ask, so the date that the certificate was of loan sale was, I asked the affiant. So let's put that up next to the certificate of loan sale, starting at number 21, Shazam. And then I ask her, what's the date? The date is 7/31/2021. Is that correct? Yes. So, and I ask her, so let's put up the bill of sale, Shazam. So we have the certificate of loan and the bill of sale, Cindy. And you can see the date of the bill of sale when someone is giving something to Upstart who then gives it to Velocity is 5/26. The certificate of loan sale, where the original creditor here, Cross River Bank, for the first time, which is called the initial seller, gives something to Upstart Network, And the date on that, as I've got to admit, is 7/31/2020. In other words, 2 months after the bill of sale. So there's nothing in that bill of sale that can be given to Velocity until the original creditor or initial seller in this case, which is Cross River Bank, and Cross River Bank, by the way, is not in the bill of sale, gives it to somebody. And there's nothing given Upstart Network, there's nothing showing Upstart Network handing the debt to Velocity 2 months after that bill of sale when the when the loan sale agreement, the first time the debt is transferred to Upstart, anything where Velocity can truthfully show it got the debt, it must come after that date of 7/31/2020. I hope that makes sense, especially with my other videos. So Cindy put up 3 question.OK, but Upstart Network, Shazam. So unless you see it differently, do you see them saying Upstart Network grants all rights and title to certain charge-off loans to Velocity? Do you see that? No, not those specific words. I don't know what words she's looking for. Either it says it does or it doesn't. So that's 6 things we got her to admit that we're going to use against her, all right? Now we ask her on that same piece of paper, same transcript. Upstart Network Inc. is not the initial seller. Cross River is, correct? Correct. Cross River Bank is the original creditor. So next to that, Cindy, put up again the bill of sale, Shazam. And you can see they're calling themselves the initial seller, which would be impossible because Cross River Bank is the initial seller. By the way, 2 months later. So this is a whole plate of wrong. And as I say in this document regarding Upstart Network Inc., showing it's not the initial seller, here is where the kill admission comes from their main witness who signed under oath that she examined all the records. So then let's put up a new one. Cindy starting at 5 and the only thing getting transferred, Shazam. So the only thing getting transferred to somebody else in this bill of sale is Upstart Grantor Trust to Velocity, correct? Velocity Investments. Yes or no? Yes, Upstart Funding Grantor Trust. And just to reiterate, that's what she says. You said before you have not seen an assignment of a transfer of anything to Upstart Funding Grantor Trust 2019-3, correct? She says correct. That's 7 things now, and it's probably more. And then to really kill her and the case. All right, so just for the record, the bill of sale was 5/26/2020. Approximately 2 months before you called the web certification. Is that correct? Yes. And do you know what a chain of title is? Yes. Would you agree there's a missing link here? No fault of your own? Answer, yes. So we've killed the affidavit. It's just really easy when you use their own documents against them. So as I should have said earlier, like and love this video. I'm just showing you exactly how I did it in depth. Hopefully it works. This works for you. I've got attached to the membership website an actual checklist for you to use, my notes, a couple of deposition notices for creditors and for debt buyers. They're good in that the questions or information I'm seeking in the debt notice, you can use in your answers, your counterclaims, your counter affidavits, affirmative defenses. So I'll break one down just quickly for you, and then I'll end this. So I ask her, Cindy, put up question if you go to your certification, Shazam. I say, but 2 months earlier, somebody is claiming the same stuff was sent to Velocity in the bill of sale. It's not your fault. You're just reporting on the paperwork. But do you see the differences? Yes. You can see it's quite a mess, correct? Miss Rivera? Yes. You can see there's a lot of differences in different paperwork, correct? Yes. So I just got done telling you we are driving a wedge between the truth and their documents and proofs. There's the 8th evidence admission of the wedge. You can see there's a lot of differences in different paperwork, correct? Yes. So this woman signed off of the truth of all these things that she's kind of admitting that they aren't true. And then I just squeeze in another one. Cindy put up one question your affidavit says that more than 30 days, Shazam. In the affidavit, she had said that a demand was made on my client 30 days before she signed this affidavit. Do you know that to be true? I ask her. It's up there. But you didn't see any demand that made more than 30 days prior to the affidavit being created. Is that correct? Yes. So you just got to admit that our affidavit is not truthful. That's important. It's so important. And what you're doing with these questions and answer, you are identifying disputes and you're trying to knock out the chain of title. And it becomes undisputed using their own documents that they do not own this debt. It's their witness. So when you do a deposition, have your goals. Look at my checklist on the membership website. It'll have tons of goals that you don't need to use all those things I put for you, just the ones that apply to your case. And remember, let's say you got a stool. It's got 4 poles, right? Holding up the part you sit on. Take one of those poles away, you're going to fall down. So don't feel as though you have to knock out all 4 poles. I hope that makes sense. They're falling down with the knockout. Me, especially, I like to, if I know that they're weak in an area, I'm going to knock out a couple of other poles. But you don't need to do that. If you can show a judge that they're making some of these admissions, you're golden. And the court wants you to do that, believe it or not. It's going to go with the debt collector or debt buyer generally because there's a lot of papers and you owe the debt and you didn't pay the debt. But if you provide them with a reason why that's such crap on that side, and your counter affidavit, by the way, I've always told you, once you write that counter affidavit, it follows you all the way through the litigation as far as you go. Your counter affidavit is the basis of the questions you want to ask. The counter affidavit does all the work, even for these depositions for you. Here's some videos I've done creating a counter affidavit. There they are, there they are, there they are. Several gone. So dig deep. Use my checklist, but I also have a checklist for you on a PDF on how to create a counter affidavit along with those videos. That's the questions you're always going to be presenting with the answers, no matter what the litigation is. It can also create a material issue of dispute of the facts that they don't own the debt with your counter affidavit. It's all about the counter affidavit, folks. But here's an example of my using the questions that came from a counter affidavit in a deposition. All right, it's another long one, probably boring, sorry. Like, love, and subscribe anyway. And check out the membership website. They still have the August $99 special with everything. It's just really cool. And starting September 1st, there's going to be something new coming up, 2024. Well, you'll see it soon. Thank you very much. Bye-bye.